We're on the record in CR 2022-00965. I'll turn it over to State of Arizona versus Samuel Bateman, and I'll turn it over to the attorneys, both advisory counsel and state's counsel, to put your appearances on the record, and the court will note the presence of Mr. Bateman in custody representing himself. Go ahead.
Good afternoon, Your Honor. Heather Mosher on behalf of Jonathan Mosher for the state, and I will note that Doug Fresquez from Victim Services is on Zoom as...
All right, thank you.
Christine Brown, Advisory Counsel. Thank you.
Oh, all right, thank you. We're here for a trial scheduling conference and Donald hearing. I think what I'd like to do is start with the Donald hearing component of things. Are the parties ready to go forward with that?
Yes, Your Honor. However, there are some things that I think need to be put on the record. This morning, I received additional disclosure, which I had never seen before. Some of it includes witnesses that have just been interviewed October 8th. I have given a copy of that to Mr. Bateman, but I think it's important for him to know that people that he previously believed would testify for him have been interviewed by the Department of Corrections, Coconino County Sheriff's Office, I believe, and DPS, and would actually testify against him. I don't know if he's had a chance to review that yet. I also received the 911 tape, which had never previously been disclosed. I tried to have Mr. Bateman listen to that prior to court. He doesn't want to listen to it until it goes through the jail and is placed on a thumb drive. So we will get that disclosed right away, but I think it's important when he considers his chances that his decision to go to trial, that he have an opportunity to review all of that, to know that the state's witness list has expanded. The only other thing I wanted to inform the court is that I calculated his back time credit with the state's current offer, which is a class 4 dangerous felony with a stipulation to 6 years. Mr. Bateman has served 2 years, 11 months, and 23 days. He would have...
I'm sorry, can you give me that again, the number of days?
2 years, 11 months, and 23 days. He would have a 3-year prison term remaining. The 85% of that 3 years would mean that all he would need to serve under this plea agreement would be 2 years, 6 months, and 19 days. And as the court is aware, I know you're going to go through all of this, but his exposure is either a class 2 category, 3 class 2 category 3s, or 3 class 2 dangerous offenses, depending on which the state elects to have him sentenced under.
Right, and you said he would have a remaining 2 years, 6 months, and how many days?
19?
19, thank you.
That's the 85% time, Your Honor.
All right.
And that would run concurrent to the 50-year federal sentence he is currently serving, which was under a plea agreement.
All right. And the court would note that the indictment, the proposed amended indictment that was adopted pursuant to a motion by the state order of the court contains 2 counts of child abuse as class 4 felonies, each with separate alleged victims, both as dangerous offenses, but modification of the original plea agreement. For each of those, do the parties agree that each of those carries a 4 to 8 year term with a presumptive term of 6 years?
I believe that's correct, Your Honor. Did you say 4, 6, and 8?
Yes.
Yes.
So essentially the plea agreement, if I understand, is essentially a dismissal of one of the counts there. Is that fair, with a stipulation of the presumptive term?
I think there are a total of 3 counts under the new indictment, so it would be a dismissal of 2 of the counts and a plea of 1.
I'm sorry, I did it double-sided and I didn't flip it over, I confess. So 3 counts, so each of those 3 counts would carry 4 to 8 with a presumptive of 6 on each of those. And then each of those would carry potentially consecutive terms, given that each one of them has a separate victim. So it's not very complicated, frankly. Mr. Bateman going over what you're facing in trial. That's it. It's those 3 counts. They are each counts of child abuse. Each of them are class 4 dangerous felonies. Each one of them carries the same potential sentence of between 4 and 8 years and a presumptive term of 6. There would be the possibility of stacked sentences, of course, entitling potentially each victim to their own respective sentence. So you could receive up to 24 years total for the 3 offenses is the maximum term that you could receive under the charges that you're going to trial on. Do you understand?
Yes, I do.
Do you have any questions about the exposure that you have at trial at all?
I don't, but I would like to submit for the record 2 motions that I have here.
All right, that's not what we're here for today. We're here to set your case for trial and to conduct a docket hearing, so that's what the court's going to be addressing here today. I'm not going to be ruling on anyone's motions here from the bench today. It's just to make sure that you know what you're rejecting in the plea offer that was offered to you, and make sure that you understand what your exposure is going to trial. That's what we're here to address. Understood?
Yes, I understand that, but he told me that I'd already lost my chance anyway, so.
He did put that on the record, he being Mr. Mosier. He had previously stated that the plea agreement was withdrawn. Doesn't mean that it's against all probability that you could potentially get the plea agreement back if you wished to plead guilty under the terms of the plea agreement. The plea offer, as outlined, was a very favorable offer to just one of the 3 counts, with the stipulation of the presumptive term, with you getting credit for all of your back time that you're entitled to, leaving you with just 2 years, 6 months, and 19 days left on your sentence. And as I recall, there was a stipulation to concurrent time to the term that you're serving in your federal case. Am I correct about that, counsel?
Yes, sir.
Yes, Your Honor.
All right. And you rejected that. Is it still your desire to reject that, Mr. Bateman?
Yes, sir. I'm going home, so I will fight till I go home because I shouldn't be here.
Very well. Mr. Bateman, you had waived time at the last setting, so let's look at possible trial dates that we could set you for. It sounds like there's still important evidence that's being disclosed in your case, and including new witnesses, the 911 call, and other items as indicated by Ms. Brown. The court could set you actually for a very fast trial, but as you expressed at the last setting, that wasn't what you wanted to do. You wanted the opportunity to prepare your case. Is that still your position?
Yes, sir.
All right. I have a very full trial schedule starting in the first of the year. The first date that I have available, I have room right now because I had some things come off of the calendar. And in our last setting, I was ready to set you in November. But if we go out with you waiting time, the first setting I have available would be August 14th. April 14th, I apologize. I have dates in August too, but I meant April 14th, I apologize. April 14th, and I know that it's still in the works as to just how many witnesses there may be on both sides. I can actually if we set it on that day, I could set it knowing that the state's indicating that the case can be tried in 1 trial week, but I can actually set it on my calendar for 2 to keep it open for the parties.
And Your Honor, I don't believe that Mr. Mosier is available then. I think he's in a homicide trial.
Okay. Well, after that, then I have a 4-day opening on June 23rd.
I believe that works for us, Your Honor.
And in transparency, that particular week I can only set it for one trial week of 3.5 days. Mr. Bateman, that trial date would work for you?
Yes, sir, that should work.
All right. I'm going to set the trial then. We'll start on Tuesday, June 23rd of 2026. On that day, that's going to be a Tuesday. On Tuesdays, I can only do a half day of trial because I do mental health court in the mornings on Tuesdays. So we'll start at 1:30 in the afternoon with the jury, and we'll go until 5 o'clock. Hopefully we'll do jury selection and perhaps preliminary instructions and openings that day. Then on June 24th, 25th, and 26th, on each of those days, I'm going to schedule us from 8:30 to 5 o'clock in the evening. On each of those days, the court will be ready to proceed with the parties at 8:30, and if there's anything that we need to place on the record before we commence with the jury on each of those days will be called to appear at 9 o'clock. That gives us a half hour of time to do anything we need to do on the record before the jury appears. It also makes it easier for jury selection because it gives people time to get children places that they need to be before they appear at the courthouse at 9 o'clock. So that usually helps that process out as well. For a comprehensive pretrial conference and motions hearing, I could set that on May 21st at 9 o'clock. That work for the parties?
Sorry, Your Honor, I missed that last part. What was the date?
May 21st at 9 a.m.
For what type of?
For the comprehensive pretrial conference motions hearing.
I believe that works for us, Your Honor.
That works for you, Mr. Bateman. So the board will set it that date. And did the parties agree that a half day setting is sufficient?
It should be, Your Honor.
Yes.
All right. At the comprehensive pretrial conference and motions hearing, and I just want, given that you're representing yourself, Mr. Bateman, I'm just going to tell you, I'm placing all of these orders on the record. I always issue these orders also in writing, usually within a day or so. So I'm going to be going over a lot of deadlines here and what happens at each of these hearings. I'm not trying to overwhelm you with that, but I do place it on the record in every case, and then you'll get it in writing here within a day or two, most likely. At the comprehensive pretrial conference and motions hearing, the court will discuss with counsel the survey monkey that will be distributed to prospective jurors and trial logistics. At the pretrial conference and motions hearing, the court will also hear all pretrial motions, including motions in limine. If a party wishes to present evidence in relation to a pretrial motion or motion in limine, that party shall be prepared to present such evidence at the comprehensive pretrial conference and motions hearing. Oral arguments will also be presented at this hearing. The deadline for filing pretrial motions will be approximately 30 days prior to the comprehensive pretrial conference and motions hearing. I'm going to just look at the calendar. I'll set that deadline for April 24th at 5 o'clock p.m. that day. Response and reply time will just be in accordance with the rules of criminal procedure. The deadline for interviewing witnesses will be approximately 45 days prior to that. That will be set a deadline of March 7th for witness interviews. The deadline for filing of information to be included in the survey monkey will be a week prior to the comprehensive pretrial conference. So that'll be May 14th at 5 o'clock p.m. By that deadline, each party shall file with the court the following items. First, a statement of the case that has been agreed upon by the parties. Second, all proposed voir dire questions that counsel wish to be included in the survey monkey. Each side is limited to 15 voir dire questions for inclusion in the SurveyMonkey. The court will include in the SurveyMonkey all the standard voir dire questions from the Arizona Office of the Court's criminal trial bench book. Counsel will also, of course, have the opportunity to ask additional questions during in-person voir dire. Third, a list of all attorneys who work at each respective office. I'll go ahead, I understand that your advisory counsel, but I'll go ahead and ask that all of the attorneys then working at the public defender's office be included for that purpose as well, given that this round will be seated at the table as advisory counsel. Fourth, the names of all witnesses that counsel or the parties intend to call at trial. Fifth, the name of the case agent to be seated with the state. And sixth, the name of any investigators or other co-counsel or staff that may be present at counsel table or before the bar. You need not include those individuals that might sit behind the bar. And these items shall each be exchanged by the parties and emailed or sent to my judicial assistant by the deadline through regular mail. In your case, Mr. Bateman. And 1 week prior to trial, which is going to be June 16th, by 5 o'clock, parties shall file with the court and email the judicial assistant, at least on the state's part as required. First, all proposed in-person voir dire questions. Secondly, all requested preliminary jury instructions. Third, and just to be clear, on the voir dire questions, the court understands that the parties are going to ask specific questions to the jurors, but what I'm really trying to get at is the general areas that the parties wish to explore in in-person voir dire. Third, all final jury instructions. Fourth, all proposed verdict forms. Fifth, any stipulations by counsel regarding the admission of any evidence. Counsel shall use the most recent version of the available Raji's, that would be Raji 6. All proposed instructions shall be sent to my judicial assistant, at least on the part of the state, in Word format, both with and without the Raji references. On the Friday before the first day of trial, which is going to be June 19th by noon, the party shall file with the court and email my assistant a list of all the prospective jurors that they've agreed to strike for hardship or cause based upon their review of the SurveyMonkey responses. So those are all the deadlines that the court wished to set for today. The court would note we set it for 3.5 days of trial. The defendant is facing less than 30 years, so the number of jurors will be 8. And would the parties like 1 or 2 alternates for the trial?
Would like to.
All right. I would assume that works for the state.
That's fine. That's fine.
Okay, we'll do 2 alternates that will sit through the trial as well. Anything else in terms of scheduling that you feel the court needs to cover, Mr. Bateman?
Not that I can think of.
All right. Anything further from the state at this time?
Yes, Your Honor, if I could just be heard briefly on the motions deadline. You were on a roll, so I didn't want to interrupt.
Okay.
The state would request, instead of the standard response and reply timeline, that after that April 24th motions deadline, that the court set a response deadline. I know that's a bit unusual, but the reason is, for example, in Mr. Bateman's 2 most recent filings, he's asserted 2 things that are factually contradictory, and so our concern is that if the state is responding to the motions as they come in, we're going to be dueling with ourselves and with Mr. Bateman. And just as an example, in his motion to dismiss, he indicated minors entered the trailer voluntarily without his, this is the motion he filed today. Minors entered the trailer voluntarily. He didn't know. As soon as he found out they were in the trailer, he stopped and pulled over, and that's when he encountered law enforcement. But in September, in his motion to dismiss, he asserted something completely different.
I understand. So what the parties, what you're asking for is for both parties to be afforded a single response deadline that would follow the April 24th motions deadline, regardless of when the motion was filed.
Yes, and I think it makes sense to do that once we know how many motions we're talking about.
Mm-hmm. I don't believe that I disagree. Do you understand, Mr. Bateman?
Yes, I think so.
So what that means is the state's proposing that usually there's an ordinary response time that applies that starts whenever the motion is filed. Instead of that, we're going to have a single deadline for filing motions of April 24th, and then the deadline for responses. I'll just look at the calendar. If it's April 24th, the court would set a deadline. I'll go out to May 4th as the response deadline. So that takes everyone past that weekend before. And so everyone will have until May. Wait, let me look. Did I look at that right? No, it would, I think I misspoke. It would be May 11th that the parties would have to file the response on any motions. Does that work for you, Mr. Bateman?
Yes, I should.
All right, and that's what the state's seeking, correct?
Yes, thank you.
All right, so I'll set a response deadline as May 11th by 5 o'clock. That's a Monday, so that gives everyone through the weekend. You can file things on that Monday as well. Anything else? I don't think there's any need for a specific reply. The reply can just be regular.
I agree, Your Honor.
Okay. Anything else?
Just briefly, I noted that this court did grant the state's motion to compel disclosure with the deadline for today. I know that Mr. Bateman filed a motion saying the state has not complied with its disclosure obligations, but still not complying with his disclosure of a list of witnesses and the associated defenses. So I just wanted to note that for the record.
All right, thank you. The court, I'm aware there's a few different pleadings that have been filed with the court. Some of those were just seen by the court just before taking the bench this afternoon. The court would be happy if the parties feel that it would be appropriate to set argument on any of those motions earlier than dealing with those in May. The court, for instance, with any dispositive motions, the court would be willing to set other hearings as the parties might request to address those motions sooner than later. Otherwise, the court will just go forward, anticipating that from this point forward, I will address those after the Comprehensive Patrol Conference in June.
Okay, thank you, Your Honor.
Was it?
Judge, just briefly, I'm not getting any of the filings, so I don't receive his pro per filings. I don't know if the court can forward those to me or if the state can do so. I also wanted to indicate that I sent Mr. Bateman a blank notice of defenses and list of witnesses, so he does have the bare bones to fill in and file. And lastly, although it will not be me, he will have advisory counsel at that trial.
Okay, very well. And Mr. Bateman, at this point, well, I just want to speak to you briefly, Mr. Bateman. Obviously, be in your interest if you're going to have an advisory attorney at the time of your trial, at the time of the comprehensive pretrial conference. it's in your interest for them to have copies of the things that you're filing with the court, so that if you're in the middle of the hearing and you want to ask them a question about something or about something in preparation for that hearing, that they know what the heck you're talking about. So you want to make sure that you include and send them a copy on your motions as well, not just Mr. Mosher. And if it's going to change, you can just send that to the public defender's office, and I'm sure that they can get it to the right attorney if the advisory attorney changes. And understood?
Yes, I do. I just assumed that they did get it, so I definitely did bear on that, for sure.
When you file it and you send it to the court, but then you only include the state, that's the only other entity that's getting it. So you want everybody to get it.
Yeah, thank you.
Okay. And would the state have any issue with just sharing Mr. Bateman's filings up to this point with Ms. Brown?
No, we'll coordinate and give you anything that you don't already have, and I can write this second forward you what we got today.
All right. Anything further?
I believe so, thank you.
No, thank you, Your Honor.
All right. That'll be all today. Thank you.
Can you just give me a list of